Okay, I see we have Mr. Robinson and Mr. Wallace on the Bills side. Are you both gonna take some part of the argument, or how are you gonna do that?
Yes, Your Honor. I'll address how we're going to divide our time.
Okay,
What we're going to do is that Mr. Robinson and I collectively represent Mr. Mills, and
Right.
Mr. Robinson individually represents Mr. Pumphrey. I'm going to start the argument on behalf of Mr. Mills, and then turn it over to Mr. Robinson for any additional comments about Mills, and then his argument about Mr. Pumphrey about any facts or issues that are unique to Mr. Pumphrey.
okay, and collectively you'll do 30 minutes, I assume, with some rebuttal time.
Our intention, Your Honor, is 5 minutes rebuttal, and I would take the first 15 minutes of the 25 that we have, excluding the rebuttal, and then Mr. Robinson would take the next 10.
Okay, all right, good, great, thank you so much. All right, well, I'm ready when you are.
All right, may it please the court. I'm David Wallace from the Bentley, Goodrich and Keeson firm in Sarasota. On behalf of Rick Mills, former superintendent at the Manatee County Schools, the petitioner in the 0891 case and the appellant in the 0677 case. He brought both, as you know, a petition for cert as to absolute immunity and a non-final appeal as to 768-28-9A immunity. My intention is probably to focus primarily on the absolute immunity issues, but I'm going to, as time permits, reach the other as well, too. And I've already described how Mr. Robinson and I are going to be splitting our time. I want to start both because it has a little bit of a procedural overview, but also there's some substantive issues in here, too. I want to talk about our decision to file both proceedings and that there's a case, Harrison versus South Broward, that is a roadmap, if you will, for both the procedure that we've undertaken and also a little bit as to the substance as well. As I said, the 768-9A immunity issue is appropriate for non-final appeal. There's a specific subpart in Rule 9.130. Absolute immunity is appropriate for certiorari review. There are a couple cases we've cited for that proposition in our brief, Florida State versus Monk and Stevens versus, I can't pronounce it, Giogan from this court. So the issue of absolute individual government employees' immunity from suit and protection from having to go to trial, which is where we are in this case, is an issue that's appropriate for certiorari review, and that sets us apart a little bit from perhaps on the certiorari issues from the school board issue that we had a little bit earlier. So we could not have properly piggybacked one on the other, so we've got the two proceedings. And I mentioned the Harrison case, so I'm going to speak to that in just for a moment here. Harrison involved the firing of a general counsel by a hospital district. There had been claims of immunity, just as in our case, under both the statute and absolute immunity. Just as in our case, those were turned down by the trial court. Just as in our case, they brought both a petition and a non-final appeal. The fourth district in Harrison found that the trial court had been wrong about an authority issue, but counsel for the fired general counsel said, hey, wait a minute, we've got other evidence of bad faith too. And the key point about the way these cases were decided together for our discussion today is that the fourth district held that even if there was a factual question about bad faith, even if there was a factual question of bad faith that might have precluded or might have properly precluded summary judgment under 768-28-9A, absolute immunity nevertheless applies even if the board acted in bad faith. So we don't need to get that what Harrison actually did is they did not ultimately decide the issue of good faith, bad faith, or not, because they didn't need to reach it because absolute immunity provided the relief from suit. And so, that's what we would say is a model here. Our contention, of course, is, and then I'll fill this in as we go, is that Mills is entitled to immunity under both avenues, 768, 28, 9A, and also absolute immunity. But we're fully aware that the debate is whether or not there were facts of bad faith that might have precluded the 768, 28, 9A. And Judge Kazam made a reference to the actual malice issue earlier. And of course, there was that debate in the briefs between actual malice and legal malice. We believe the standard is actual malice. But even if there's a question of fact as to actual malice, we still have absolute immunity. So let me address now an issue that is common to both immunities, and that's the scope of employment. It's a core issue in both the petition and the non-final appeal, is whether Mills, as superintendent, was acting within the scope of his employment when he oversaw the investigation of the baseball program as a whole, and of course, the EMRF reporting as to Canaan, in particular to the DOE, stemming from the investigation. Yes, Your Honor. Oh, I thought you were about to ask a question. Sorry.
Your sound just dropped out for a sec, so I was about to tell you that, but it came back. So
Okay. So in our view, this is the easy part of the analysis. This is Mr. Mills was the top of the pyramid in the employment structure of Manatee County Schools. He's the head employee. He oversaw the investigation. He oversaw the sending of the report. And so logic and common sense tell us that he had the authority over that process. And then we've also heard in the earlier argument, and I'll touch upon this a little bit too, about the statutory authority for pursuing an investigation and overseeing an investigation. Before I do that, I want to address what is the standard for scope of employment. And there was some disagreement in the briefs about that. Canaan's counsel had a different test that I think is the wrong test. They had a test that I think they called the public good test. I think the proper test is that as stated in the Cassell versus India case and several others. Cassell versus India is one that seems to be cited a lot. And in this case, it was in the context of absolute immunity. The scope of an officer's duties is to be liberally construed. The term duties is not confined to those things that are required of the officer, but rather extends to all matters which he is authorized to perform. So we've got liberal construction and authorized as opposed to required. And our contention here is that Mr. Mills was not only authorized to oversee this investigation, he was required to do so. It's part of his statutory job description, if you will. We've heard about the 30-day reporting requirement for the school district of a complaint that is legally sufficient if it contains ultimate facts. And I'll get back to that in just a second. A companion section of that same statute, but when we're talking about 1012.796 D4, if the school district superintendent has knowledge of a legally sufficient complaint and does not report the complaint or fails to enforce the policies and procedures of the school district and fails to comply with the requirements of this subsection, in addition to other actions against the certificate holders authorized by law, the school district superintendent is subject to penalties as specified, and then directs you to the other section.
So how does that fit with the allegation here? Is that he had knowledge of the legal insufficiency of the complaint?
Okay, and first of all, we don't agree with that, Your Honor.
Of course not. But
I understand. But let me. We think that the record does not show facts that he had knowledge of the legal insufficiency at the time the 30-day first EMRF was sent. And in fact, I thought I heard Ms. Seymour in her argument describe the responsibility of Mr. Canaan with regard to the coaches beneath him as athletic director as a disputed fact. And indeed, in their brief, they describe it as a disputed fact. And I think one of my points, Your Honor, is that when you have a 30-day time frame to file a complaint with the DOE based on, and this was triggered by a parent complaint. This was not out of the blue. This was triggered by a parent complaint. So there's something happens from the outside, starts a clock running, investigation starts. Kinnan did say the things he said to Investigator Pumphrey about his responsibilities.
Right. And here's the thing. In that 30 days, they could not have looked at his job responsibilities on paper, at his contract, at his assigned responsibilities, you know, and sorted out the difference between, yeah, I'm responsible for that, but it's actually HR who does it. And they couldn't figure that out.
And my answer to that is, of course, hindsight is 2020, but remember, we're doing hindsight.
The thing is that, all these briefs that everybody's filed is peppered with reference to that conversation, but none of them on the defense side refer to what his actual duties were in the books. They all hinge on that conversation. And this is a professional standards investigator and the superintendent, and they don't look at his contract.
And I guess my answer to that, Your Honor, is it's also possible they got it wrong. I'm not. It's
also possible that they were willfully ignorant because they said, we got him to say this stuff, and now we can contend that was his responsibility, even if it wasn't.
Well, I got him to say this stuff. He answered those questions the way he answered them, but I
understand that, but
my point is that the absolute immunity, ultimately, when I get deeper into that law, would still apply.
No difference whether they were badly motivated.
Absolutely.
And I know you're not on this part of the case, but looking back at the school board's liability for failure to supervise or negligent supervision, let's assume that your clients are absolutely immune, but they commit acts that would otherwise constitute malicious prosecution, right? But they can't be held liable for it. Can the school board still be held liable for negligent supervision?
I honestly do not know the answer to that question, Your Honor.
I think it's an interesting question because
I think
if they engage in bad conduct, hurtful conduct, for which they are immune, can the school board who's supposed to be supervising them be held liable? I mean,
I honestly don't know the answer. My focus was on the absolute immunity that protects Mr. Mills.
Yeah.
And the absolute immunity that protects Mr. Mills, and I'll jump to that now, because the same Castle versus India case quotes, I think it's the McNair case, where they talk about because of the balancing of interests favoring the public official, it is considered better, and this is the quote from McNair, better to leave unredressed the wrongs done by dishonest officers than to subject those who try to do their duty to the constant dread of retaliation. So the concept of absolute immunity has already done that balancing test. And the balancing test is, and by the way, we strongly contend that Mills did not do anything dishonest or in bad faith here, but the balancing test has been done in the law with regard to absolute immunity, and it is that we'd rather protect that guy who steps over the line, that one guy who steps over the line, than subject all of these other people to years of litigation where they shouldn't be subject to litigation. And so absolute immunity, it's a fairly broad policy, and it's stated broadly that way. That same policy is reiterated in the Harrison case that I made reference to a moment ago. And it applies to one of the other. The immunity extends to words and acts within the scope of the authority. And I don't think there can be a real question, but that Mills had authority over this subject matter. He had authority of it, and the privilege in Harrison also says the privilege applies to other torts beyond defamation. Now, there have been some debate about that. We cited a number of cases that show that it's applied to other torts beyond defamation. I don't think either of us had a case that was about malicious prosecution. however. But when you think about the allegations here, it is that allegedly false statements were made and sent to the DOE. That's a claim that's in the nature of defamation to begin with. So we think there's no reason within the case law to tell us that absolute immunity does not apply here. Again, the key distinction, I think this is from the Gay case, which is also a 4th District case. It applies however false or malicious. And this court in Stevens has cited with approval the McNair policy that I spoke to a moment ago. So that's the policy that's out there. This case is a perfect illustration. We're here, debating whether or not he did this in bad faith or not in bad faith. But it's been said in their briefs that this is a disputed issue as to what Canan's responsibility was. The policy in absolute immunity is to protect the public officer in situations exactly like this. This person can, even if he stepped over the line.
So would your clients, and we're now at your 15 minutes. I'll
okay.
help you go over it, but would your clients be immune from DOE punishment if the DOE determined that they had knowingly filed a false or misleading report to the DOE?
I don't know what the DOE rules are on knowingly filing false reports, but I do know this: the DOE got the entire investigative report below, conducted their own investigation, and found probable cause.
Yeah.
So it's not like the DOE looked at it and said, "What were you guys thinking when you filed that first EMRF?" They did their own investigation, found their own probable cause. So I think that's where that leads us. I would have gotten a 768-28-9A, but I'll stop now to give Mr. Robinson his time, unless there are other questions of me.
Okay. All right, Mr. Robinson.
Thank you, Your Honor. May it please the court. My name is Rob Robinson, and I've got the privilege of representing not only the appellant petitioner Troy Pumphrey, but as co-counsel for appellant petitioner Rick Mills. I would say at the outset that I certainly adopt the arguments of my learned co-counsel, Mr. Wallace, that he made in support of Mills's appeal and petition. Mr. Pumphrey's in the same boat. The summary judgment denied both, and we have an appeal of that order as a non-final order on the basis of 768-28-9A immunity, and then the separate appeal, the separate writ relating to absolute immunity. I didn't hear any questions from the panel about the appropriateness of the writ of cert, but I believe Mr. Wallace addressed that. Florida State University Board versus Trustees versus Monk, I think, deals with that issue in terms of where the not only the departure from the essential requirements of law, but where this irreparable harm was going to occur if this issue of immunity is not determined. We were on the cusp of a 4-week jury trial, and depending on what happens here, that's where we're going to wind up going back to. So we have these two defenses of 768-28-9A and absolute immunity, and frankly, they come to a point of commonality in first, and I believe for this panel, first to determine was the actions of Mr. Pumphrey within the scope of his employment. One thing that we have, and I'll direct the court in the appendix to 2 documents, because we have some specific written documents concerning the scope of any OPS investigator's duties and responsibilities. There is a written job description for OPS investigator. It can be found in the appeal appendix for Pumphrey at 4735. I want to talk a little more about it later, but basically he gets complaints, or they get complaints, they conduct investigations, they report facts, they prepare written documentation, and lastly, they forward disciplinary packages to something called professional practice services, which your honors probably already know is an arm of the DOE that deals with the disciplinary actions against those who hold a educator's certificate.
And does it matter whether this Mr. Pumphrey deviated from the prescribed flow chart? My understanding of the record, and correct me if I've misread this, because there have been a lot of allegations back and forth.
Sure.
But as I understand it, he creates the file, consults with the staff attorney and possibly the school board attorney if necessary to determine a course of action. It's my understanding that he was just told by that there's evidence in the record. He was just told by Mr. Mills, here's a complaint, proceed and investigate this. And he conducts an appropriate investigation, and then the flow chart says report the findings to the staff attorney. My understanding from the briefs was that that did not happen.
I
And-
believe, Your Honor,
and
that,
there's a committee meeting to determine disciplinary acts. My understanding, none of that happened.
well, what I was going to say was, I believe there was no staff attorney at this time. So I believe that gentleman gave a deposition. I can't remember if it's in the appendix. It was possibly put there by Mr. Canan. The point is, if there is no attorney, I'm not sure who he would have consulted with.
Or then there's a committee to determine the appropriate disciplinary action.
That did occur, but understand that that didn't occur before the 30-day window. So
Right, before this report gets made, even though the flow chart says report legally sufficient complaints to DOE after that committee meeting.
well, that's what the flow chart says, but that's contrary to what the statute says. And frankly, it's
Well,
also
the statute says file a legally sufficient
within 30 days. That
within
is
30 days, but you got a flow chart that says, and this is a prescribed, is I guess a rule of the.
understood. I think given the potential for penalties under the statute, and
I get to ignore the rules.
submission of the EMFR to DOE doesn't do anything. It doesn't start a DOE investigation. It doesn't do anything. What happened afterwards, Mr. Pumphrey completed his investigation. It took him another 45 days if memory served. That entire investigation and all its attachments, and you can see it's in the record, all the people he talked to, the transcripts, the documents, the emails that you had mentioned from HR, all of that is then transmitted to DOE. And it's not until that point that DOE decides they're going to open an investigation. That investigation involves the assignment of their own internal investigator, Nicholas Searman, who spends, I think, 18 months investigating this and winds up with a report plus exhibits that's actually about 450 pages. It's that is submitted to at that time, the Commissioner of Education, who made Ms. Sanders, that made the determination of probable cause. But for our purposes, the question I think that this panel would address is investigating something and eventually reporting it to DOE, is that within the duties and responsibilities of an OPS investigator? And I'm just pointing out to you that in his specific job description and in, and I believe you've already talked about it earlier, it's School Board Policy 6.13, that is a duty and responsibility at some point of the OPS investigator, of which Mr. Pumphrey held that title. So I'm just making the point that it's very hard, I think, to argue that conducting, if you're an OPS investigator and you conduct your investigation, that somehow that's outside the scope of your employment. We're not talking about Mr. Pumphrey waving a picket sign at 7 o'clock on a Friday night in advance of a football game, alleging that Mr. Canan's a crook. These are things that occurred, and I want to cite to the court, the standard for determining the scope of employment of public officials is laid out in the Casile India case that Mr. Wallace referenced to you. What he didn't read to you, though, was the actual test, which is that conduct is within the scope of one's employment. If it is the type of conduct which the employee is hired to perform, the conduct occurs substantially within the time and space limits authorized or requested by the work to be performed, and the conduct is activated in at least part to serve the purpose of the employer. So our position, Your Honor, and by the way, this public good test is not, is not the test. And Mueller is the case they cite for that. And Mueller that is a Florida bar attorney discipline case that involved an attack against the actual prosecutor of attorney discipline at the bar. But Mueller makes no such holding. Mueller actually applies this test, which is the three-part test for determining employment. But it's my position that you can't credibly argue. You might disagree with how he did it. You might disagree with the timing of when he did it. but is an investigation and ultimate transmittal of potential misconduct within the 30 days, is that within the wheelhouse, i.e. scope of employment of the OPS investigator? And I just don't see how it's not. So Mr. Wallace made the point, we've made the points in the briefs that that we do not believe there's any evidence here of actual malice, which is the test for the 768-9A side of the equation, 28-9A side of the equation. But honestly, you know, I've tried to find fault with the Harrison case or some distinction with the Harrison case. It's really hard to do that. It just seems to be, Judge Blue used to tell me when he was a circuit court judge, that it's on all fours, Mr. Robinson. So, so if you look at it, you know, and you know, I don't like to. I think that when you look at the end of this case, there's an examination here. Stratus, by the way, in that case was the lawyer that had been terminated. So the opinion as written says that Stratus contends that the defendants, and by the way, those were two board members whose authority to take the action was under question, are not immune under 768-28-9A because she, and Stratos was a woman, presented sufficient evidence to show that means the two board members, acted in bad faith and a malicious purpose. The conclusion there is that even if this is correct, the common law privilege absolutely immunizes defendants, the two board members, for the tort claims and issues. Now, bear in mind, Your Honors, that this court looked extensively to determine whether what the board members did was within the scope of their authority. Now, I don't believe they were employees, which is different than our case, but they looked at it in the extent, was it within their wheelhouse of authority, and they said it was. So
you were right at the rebuttal time, Mr. Robinson.
Okay, and I do want to leave that for my my good friend, Mr. Wallace, and I appreciate you all listening to us today. Thank you.
Okay, thank you. And someday we'll swap Judge Blue stories.
Thank you, sir.
Okay, Ms. Seymour.
May it please the court. My name is Jennifer Seymour, and I represent the commands in this action, the appellees. Under 768-28-9A, there's no absolute immunity from suit in a malicious prosecution case. And my colleague here has said that he believes the Harrison case is on all fours. I would equate it to a three-legged table without a leg. The Harrison case in particular, that's Harrison versus South Broward Hospital District, 382 Southern 3rd, 695 at 701. Again, that's a Florida 4th DCA case. It hardly addressed 768-28-9A. Instead, it relied upon a common law privilege afforded to public officials in claims for defamation. And I would point out to the court, common law immunity is not at issue in this appeal and has never been applied to a malicious prosecution case. To continue, Ms. Mills as the superintendent, as the top of the pyramid, as our colleague had said, the issue is a potential abuse of power of how he handled the investigation in the first place. And he was supposed to report, Humphreys was originally, the investigator was supposed to report to legal counsel, that was Mr. Gagnon. There is some discrepancy over what time period there was legal counsel, but my understanding is that there was during this pertinent time frame, and that the job description was changed at the same time that this investigator was allowed to be an investigator when he didn't even qualify under the existing responsibilities and requirements for an investigator. So the whole thing about how he became involved in this case and how he was allowed to continue investigating and reporting directly to the superintendent, again, is all tied up with the fact pattern that exists in this specific case that is unique in this area where Manatee School Board, Manatee County had clearly some issues going on that are unique. Bad motivation absolutely matters here. And that's part of what the judge has found, that there are disputed issues of material fact. To equate a chilling effect, though, on behalf of all superintendents because of this case, just ignores how unique this set of facts is and how I hope that it would be unique, because the political and personal animus that's been alleged here is quite disturbing. I do not believe that it happens in school boards across the state. I hope not. But I think this is a very specific factual issue, and that is important here when we're talking about the standard that should be applied. To equate a superintendent looking at something like a report of actual child abuse or endangering child welfare and looking at this case for precedent and saying that, you know, they're not going to report it because they're worried about this case, it just ignores all the unique facts in dispute. So in terms of the writ arguments that have been made, that it would somehow have a chilling effect or somehow negatively impact children, that's just nonsensical. That's not the issue in this case.
What about the argument that it's immunity from suit? So
That's not applied here either, Your Honor. 768-28-9A does not allow that. For purposes of 9A, there are three things. It's an or situation. So bad faith, malicious purpose, or a manner exhibiting wanton and willful disregard of human rights, safety, or property. Additionally, if they act outside of the course and scope, it's not just because they're using their role, it's the way that they've conducted themselves. That takes it out of an immunity that they would have. If that answers your question, Your Honor.
well, that I'm assuming you're presuming that the absolute immunity doesn't apply.
Correct.
But if it did, there would be irreparable harm because the immunity is also from suit. Correct?
No, the immunity here, they're trying to conflate the immunity with defamation cases. That's not at issue here. The issue is the way that they conducted themselves in bad faith or with malicious purpose is the underlying tort. It's part of the underlying claim of the malicious prosecution claim. We can't bring a tort like that to the school board, but we can hold the agents, these particular individuals, responsible for the actions that they did. There's a difference between bad faith and malicious purpose in claims against the state versus claims against the individuals, and we've set that out. Regardless of whether 9A is about actual or legal malice or a lack of probable cause, as some courts have defined legal malice, we have disputed issues of fact for both that we've set forth in the record and that the court looked at when it was applying the test in this case. And there is a problem with the way that the defendants erroneously claimed the key issue of Mills or Pumphrey had the authority to conduct the investigation. That's not the key issue. We agree that they had authority. There's no dispute here that the key issue is in conducting that authority. Did they act with malice or bad faith such that it became a malicious prosecution? And just because another department investigates it does not absolve them from the way that they conducted themselves. Mr. Canan also was not the athletic director. There's still some dispute, and the appellants tend to conflate the responsibilities for business manager versus athletic director is the same, but they're not. A lot of the schools, there was a change in the way that they were approaching coaching and the sports. And some of the schools, including Manatee High School, decided that they were not going to adopt a certain position. So there's still some confusion of that in the facts, but again, that would be a disputed issue of fact. In terms of what Mr. Canan has said, with all respect to football coaches across the country, he's a well-respected football coach. He's not an attorney. He was not making a representation that he was responsible for that act. He was trying to comply with the reporting, talking with the investigator and talking with the school board on all of that. Absolute immunity does not apply to a malicious prosecution. And in this case, it's not just false statements. It's the way that the conduct came across. The defendants make a conclusory statement that no reasonable jury could conclude that Mills or Pumphrey acted in bad faith, but that's for the jury to decide. Whether the conduct evinced bad faith or malicious purpose, it's a highly fact-specific inquiry. And that generally prevents the courts from concluding as a matter of law and summary judgment that sovereign immunity applies. That's, again, why the courts have found in this case that it doesn't. This allegation that there was a serious patient or parent-initiated complaint, it had to do with a whole lot of other facts, including some funding issues that were happening, where Mr. Mills was attempting to find funds and take them from sports that put him at issue with Mr. Canan and his business, or his drive to make sure the football team was the best, that put them at odds. But whether it's a serious patient or parent initiated complaint or not, if it's a false accusation, you don't just report it, even if it's serious. That actually makes it more important to do some investigation. And this 30-day window is also doesn't absolve them of what they've done in this case, because they had time to look at it, and they did. They knew he was not responsible for getting some of this information to HR. HR was responsible for it. This was a trumped up way to get Mr. Canan, force him into retirement, or terminate him. And that was the pressure that was exerted on him. Yes, Your Honor.
So you contend that absolute immunity doesn't apply to the malicious prosecution action. But you'd agree that that's been applied to IID and tortious interference claims. What's the pertinent distinction between application of absolute immunity to a tortious interference claim or an IID claim based on allegations of false statements, and application of the absolute immunity to a malicious prosecution claim based on allegations of false statements?
Some of this was addressed in the Olson court, which again was the second DCA. This was decided after the Stevens case that has been repeatedly referenced by the appellants. The court is addressing the confusion of the law regarding, conflating defamation with malicious prosecution. And in doing so, the court said, Johnson confuses the law of defamation with the law of malicious prosecution, which is an issue in the instant case. Olson made no claim based on defamation, and the fact that defamatory statements may have been made in the course of the conduct, which Olson alleges as the basis for his claim, does not transform that claim into a defamation claim that is subject to an assertion of absolute privilege.
Are you sure that Olson was adjudicating absolute immunity claim, not a litigation privilege claim?
It was a litigation privilege claim, correct. I'm
Right,
just
so
saying
what-
that the court was trying to explain the difference between defamation and malicious prosecution in that case, as well as what we find in our instant case. There's some confusion. The appellants have cited numerous cases that have to do with defamation or intentional infliction of emotional distress and other claims that are not at issue with this case. This is about a malicious prosecution.
Well, that's why I'm asking you what the pertinent distinction is. If absolute immunity can be applied outside the context of defamation based on other causes of action premised upon allegations of false statements, what's the pertinent distinction between applying it to malicious prosecution if that particular claim in the particular case is based on allegations of false statements?
IID and tortious interference cases are found to be a retooling of defamation. It's a different situation here. Absolute immunity does not apply to malicious prosecution, and it has not been, there's no authority to suggest that. This case is not about false statements.
Why is it not about false statements?
It's about the malicious prosecution, the fact that they were using false statements to their ends of trying to force Mr. Canan into retirement.
So you wouldn't contend you contend that the absolute immunity is not a per se immunity from all defamation suits, correct?
Correct. And it
Right.
depends on the
It's immune. Is it the conduct that's immune, or is it that it's just all officials are immune from defamation suits?
It's more about the defamatory nature of the statements, and that is
Right.
not
So it's
the
if based on that, if it's the conduct that is immune, then why would another cause of action, one that maybe doesn't happen to have been adjudicated or reviewed in a recorded case law, also based on the same conduct that is immune, not be foreclosed by absolute immunity?
I think that's holding it outside of what these cases have done. I think that.
Well, what is the essential? What could the essential requirements of the law not be that a specific holding regarding a specific cause of action, but rather the holding across a broad swath of cases, contending that if the cause of action, by whatever name rose is a rose, it's premised on the conduct that is immune, which is statements made within the course of the public official's duties. Could there be a departure from that, which seems to be a clearly established law meaning, hey, it doesn't matter if it's defamation or not. If you've premised it on statements that are immune, alleging that they're false, it could be an IID claim. It could be a tortious interference with the contract claim, and we're still going to apply immunity. Isn't that isn't that established law?
I think that confuses a little bit of the issue that's involved in this case. Absolute immunity is not barring a malicious prosecution as a matter of law. Absolute immunity afforded public officials for statements made in connection with their position in a defamation action has not been extended to malicious prosecution and what we've alleged in this.
Well, I'm conceding that, but what is the holding of those cases? The holding of those cases is that you could characterize in two different ways. One is that it this malicious this absolute immunity no longer applies solely to defamation, but also applies to an intentional infliction of emotional distress claim based on allegations of false statements. That's one way to characterize the holding. Isn't there another way to characterize the holding more generally, to say that in causes of action that are premised on this conduct that is absolutely immune from liability in suit, to it statements made in the course of their duties, that any and all such causes of action are absolutely immune, are barred by absolute immunity? Why
I
not?
understand your point, Your Honor. The court has limited its holdings in several of these cases, though, the specific factual.
Yep. Well,
situations
can you
that
point to
happen.
language in which it says it limited its holding?
Well, in Stevens, for instance, it expressly limited the holdings for claims to intentional infliction of emotional distress. That's 702 Southern 2nd 517 at 522. It's about the intentional infliction of emotional distress in that case. And then Olson, which I had cited, was the second BCA in 2007. So about 10 years after the Stevens court had looked at things. The court was addressing the confusion of defamation with law of malicious prosecution. And the cases that are cited by petitioner limited the holdings to claims at issue therein. I think for instance, some of the other cases that have been cited are distinguishable because they're not involved in the kinds of claims that we're alleging in this case. Specifically, we're alleging there's only malicious prosecution against Mr. Mills as the superintendent and malicious prosecution against Mr. Pumphrey as his investigator. Absolute immunity also does not protect the petitioner because he was acting beyond the scope of his duties and not acting in the public interest of public good. This is usually applied to statements made by public officials to the media. In this case, we know that Mr. Mills harbored personal animosity towards Mr. Command. There's at least record evidence of that.
Aren't you on that argument? Aren't you conflating the tortiousness? What makes the conduct tortious with what makes the conduct either within or without the scope of duties? In other words, if by your logic, every single defamation case is outside. If it alleges false statements, then therefore it must be outside the duties as well. Why even why even bother with the scope of duties if you've alleged that the defendant has done something for his own personal interest out of malice or induced false statements? Under your logic, it's per se outside of his duties, because in other words, the duties only include good stuff without bad motives.
That's not exactly what I'm suggesting, Your Honor. Here, the duties required specific actions to be taken by the investigators, which were not, by Mr. Mills as the superintendent, which was not. So it's not just about the defamatory nature of the statements. And I would point out that there is no defamation claim that's currently at issue. There's not an IAB claim currently at issue. The only issue is malicious prosecution and the way that they conducted themselves in failing to actually conform with the statute and provide a legitimate, legally sufficient complaint. They acted outside of all of that in the way that they behaved, and it continued for their own political and personal animus.
But the making of complaints you know, that's within their scope of the duties, right? I mean, in the investigation of complaints, you wouldn't disagree with that.
No, Your Honor, but it has to be legally sufficient. It can't just be because you want to take someone out or get rid of somebody that's causing you problems in your, elected capacity because you don't like them or you want to get rid of a political opponent. I mean, that's not what this is designed to protect. I think those are very different factual situations from what is being brought up in the cases that petitioner relies on, which are often in the context of a police officer or something else. It's a very different context.
Let me ask you this. Let me ask you this. Let's say I'm just picking at random in case let me ask this. So the law recognizes that a public official could defame someone and still be acting within the scope of his duties, right?
Correct. And we have First Amendment protections that are important and with, the way that we conduct our elections.
So that presumes that whether or not they undertook those duties in a way that's malicious or in a way that is negligent or in a way that is bad, for lack of a better term, doesn't have anything to do with whether those duties fall within the scope of duties, whether that conduct falls in the scope of duties, right? Because you just agreed that case law presumes that one could, as a public official, be acting within his scope of duties and defame someone. So
that's a different situation than we're presented with here. And
I know, but you can't follow the analogy. So then, so in other words, you're saying you're saying the falsity of the statements takes it out of the scope of duties.
No, Your Honor, I'm saying.
How's that true if the falsity of the statements in a defamation case doesn't take it outside the duties?
But that's not exactly what I'm attempting to
If I may,
argue,
Ms.
Your Honor.
Seymour, let me see if I could understand the exchange. Is it your position that the duties, at least for these two individuals, their duties require that they take specific action as investigators? And you're alleging here that they did not do that. And they act outside the scope, the way that they behaved, that basically was legally insufficient, because the standard, they have to be legally sufficient. So that takes it away from the defamation type of cases and there's really no case at all that ever extended that to malicious prosecution. In fact, this is the case of first impression in front of us. And so the question is that defamation that we're following, this is within their, legal, within their scope. You're alleging here that this was outside the scope and it wasn't legally sufficient. Is that what I'm understanding you?
Yes, Your Honor. I am pointing out that they did not undertake the duties that they should have done. Whether they added false statements included with that doesn't take it to defamation context.
But does it take it outside of their duties? You're saying it takes it outside of their duties.
Correct. It takes it out of the scope for purposes of.
Well, then why in a defamation case does the falsity of the statements not take it outside the scope of duties?
I think it depends on the defamation case. What we have before us is not a defamation case. What we have before us is a malicious prosecution, and 768-28-9A does not provide any immunity for that. That's part of the issue here.
I'm still talking about the scope of duties. I'm not talking about I'm talking about whether this is within the scope of duties. And you're saying that because the complaint was insufficient, that it's not within their scope of duties. But the insufficiency goes to what the ultimate success or failure of the complaint. It doesn't go to whether making complaints is within the official duties of the public official who's asserting the immunity.
I didn't follow that because my understanding, frankly, and I'm not trying to argue one side or the other, but my understanding is they had a duty to submit legally sufficient complaints.
Right.
And
the insufficiency.
The plaintiff's argument is that they knowingly failed to conduct a proper investigation and knowingly submitted false or misleading.
Yeah, but the absolute immunity applies to even malicious conduct.
Yeah,
so
but the
maliciousness can't take it without the maliciousness. If absolute immunity applies to malicious conduct, then the maliciousness of the conduct cannot take it outside the scope of the duties to which it applies. The fact that absolute immunity the courts presume that malicious conduct can be found immune, presupposes that someone can be conducting their affairs within the scope of their duties and still be acting maliciously. And the fact that the courts have found that absolute immunity can apply to defamation cases presupposes that individuals can be asserting false statements against the plaintiff and still be acting within the scope of their duties.
I think that's a different situation than what we have here. It's not the malicious nature of the conduct. It's the fact that the conduct was done outside of the duties. And
Well,
it was not
Judge
taken
Northcott
into
just said it was the
public-
malicious nature, and so I'm trying to follow what your argument. If it's not that by being malicious,
That's not what I meant to say. I said they had a duty. It's not the ultimate success of the complaint that determines whether it was legally sufficient. They had a duty on the front end to submit a legally sufficient complaint, and the allegation is that they intentionally did not submit a legally sufficient complaint because they knew or knew that it was false and misleading. That's what the allegation
and
is.
you're saying that takes it outside the scope of their duties?
I'm not saying it, but that's what I think where the pieces are on the checkerboard right now. But
Mr. Pumphrey was not authorized to make false or incomplete or incorrect complaints. And Mr. Pumphrey's assertion that he was required to submit the complaint against Mr. Command pursuant to the statute is unfounded. The statute requires only that the school district file legally sufficient complaints, and a complaint containing information known to be false or misleading cannot be considered legally sufficient. So that's really where we're saying that there's also, penalties for failing to report a legally sufficient complaint. Here, it's just a different situation. Absolute privileges are based chiefly on a recognition that the necessity of certain persons, because of their special position or status, should be free from fear that their actions in that position might have an adverse effect on their personal interests. There's no danger here that holding Mr. Pumphrey or Mr. Mills liable for malicious prosecution would lead to fear among others in their position, but their actions would have adverse effect on their own personal interests, because investigators are not required to make legally insufficient complaints. There is no punishment for failure to make a legally insufficient complaint. The issue here is that they failed to do what their duties were, that all an investigator would have to do to avoid an adverse effect on their own personal interest is to practice due diligence when investigating complaints and refrain from submitting complaints that are known to be false or misleading like they did here. And this type of behavior is exactly the purpose of a claim for malicious prosecutions. It's meant to deter people from using the threat of prosecution in furtherance of their own personal or
You'd go further than that. You'd say in order to be fulfilling their duties, they can never submit an insufficient claim. But I'm sure insufficient claims are filed all the time, and then they're found later to be insufficient. I mean, that's what happens. You never had a complaint that you filed. You never lost on a motion to dismiss. Were you not doing your duties as a lawyer when the judge ruled that your complaint failed to state a cause of action on which relief can be granted?
I think those are different situations as well. In the terms of a motion to dismiss, also you're often allowed to amend. It doesn't mean that it's legally insufficient. And as an officer of the court, you have a duty to make sure that there is, something legally sufficient. It's a different situation, though, compared to here, where there's a specific statute that even defines what legal sufficiency means, and they failed to do that. They weaponized the statute, is what we're alleging here. They weaponized it against someone that they had personal and political animus against, and it's a unique set of facts. That's part of the issue that's challenging in this case, Your Honor. And if you have any other questions, I'm happy to address them specifically or cede my time.
okay, thank you very much, Ms. Seymour. And Mr. Wallace, I understand that you're going to do the rebuttal. Is that correct?
I am, if I can find my mute button. Yes.
Okay.
All right. Just a limited number of points. Let me start first with a reference to the Stevens case, because I think it picks up, I think it was Judge Atkinson's questions about certiorari jurisdiction. Stevens addresses that, and I hadn't noticed till I was sitting right here, right now, that I think, Judge Northcutt, this is your opinion, the Stevens opinion.
Oh, great. Thanks, Mr. Wallace.
And it has a discussion about certiorari jurisdiction and absolute immunity, and that's where we are. It's immunity from suit, it's immunity from having to go to trial. That's why this is appropriate for certiorari review. The Monk case is the other case that Mr. Robinson had mentioned earlier, but we think that this is clear that absolute immunity is an appropriate subject for certiorari review.
Yeah, but
Next
I think what Judge Atkinson was getting at was how do you, at what level do you view departure from the essential requirements of law? Can we find a departure from the essential requirements of law even where there's never been in the case law an application of this absolute immunity to a malicious prosecution claim, or would you look at it from a greater distance?
Okay.
I think that's what Judge Atkinson.
Okay,
I don't want to put words in his mouth, but I think that's.
Well, I'll answer that question then.
I was saying both things, and I'm interested in your thoughts on both.
But Stevens addresses the broader point about absolute immunity and certiorari jurisdiction. I'll address your more direct question, which is none of the cases that I'm aware of, that uniformly these cases talk about, well, it might have started with defamation, but it applies to other torts other than defamation. And of course, each case has its own tort, so it only talks about that tort. And we don't have one that says it applies to malicious prosecution, and we don't have one that says it does not apply to malicious prosecution. But when we do that,
here the question, and I see the distinction I think that the plaintiffs are making is that, okay, so you have a defamation and you employ that defamation as part of your effort to drive this fellow out. But also is the filing of the complaint with FDOE, which is part of that, and knowing that it was false. That's not strictly defamation. That is filing a complaint. That is like suing somebody. That's, you know what I'm saying? It's
yes, and it doesn't have to be just the Harrison case has a phrase in it. The immunity extends to all words or acts in the scope of authority. It's not limited to just. It doesn't have. This grew out of defamation, I believe, but it's been applied regularly to other torts, and it applies to words or acts. And here, the heart of it is, when we've been talking about it all morning, is this allegation that Mills and Pumphrey put false statements in the first EMRF. That's very close in close cousin to defamation, and I don't think there's any suggestion in the existing case law that this is a tort that this would not apply to.
Nor vice versa. I mean, they didn't just walk around the halls and say, Canan, let this coach without a certificate. They went after his license, went after his certification.
They made a statement, which we don't agree was false, but they made a statement and put it in the EMRF. They conveyed Canan's words to the DOE, and now Canan is saying that and I understand Your Honor's point that maybe that wasn't complete, but the 30-day investigation window, I don't
give them enough time to pull his contract and look at it.
I understand your point, but are they going to? But there are supporting facts in the EMRF. It is legally sufficient from that perspective. There are no cases that say, "Oh, here's a tort this doesn't apply to. Here's another it doesn't apply to." The Olson case they cited doesn't say that. The Olson case is about. I think we said it was about litigation privilege. It's also about non-government individuals. So that doesn't make the point. So what we're left with is, and there was some discussion about 768-28-9A in counsel's argument, but I think what the real focus that we're at here, because I can hear from the court's questions that, obviously the lower hanging fruit for us is absolute immunity, because it applies even when there are bad acts. And so we can presume that they knew that they should have looked in his file, for example, and should have looked at his job description, and instead they just used his words from his interview. If you presume that that's bad faith, absolute immunity protects it. That's what it's there for. And it's there, even though it kind of makes us feel a little bit bad that somebody got off the hook for doing something wrong, but the policy is built into the community. The policy is built in through the McNair case and through the Stevens case, which Your Honor wrote, which cited McNair. And so our closing position is, if nothing else, Mills and Pumphrey, for the same reasons, are entitled to absolute immunity for their words and acts in putting what they put into that EMRF 1. And if there are further questions, I'm happy to answer.
Just every time you say EMRS, I think ASMR. Nearly the same things.
Okay,
Okay, thank you both very much.
thank you.
Thank you all very much, brother. And I will briefly, now that we're finished with the case, I'll just very quickly tell you my Judge Blue story, which is the very first day as a DCA judge. My office was next to his, and I walked in and there were files all over my desk, and he walked in to see how I was doing. And I said, I'm kind of overwhelmed by all of this. And he goes, don't you worry. This is a collegial court. I promise you, I will tell you how to decide every one of these cases. Typical Judge Blue. All right. Thank you. Thank you all. In order to leave our virtual courtroom, you click the leave button or icon in the lower right-hand corner of your Zoom screen, and you'll head off. Got no idea where, the ether somewhere. And done. Thank you all very much.
Bye.
Thank you, Your Honors.
Okay. And with that, we're adjourned.